This is the Kelso Report Supreme Court Review for the October term 2010, and I'm your host, Clark Kelso. We cover the October term in 4 separate installments, covering commercial and civil law, criminal law, constitutional law, and government law. In this installment, we take a look at the major cases decided by the court in the field of criminal law. Now, even with the appointment of Justices Sotomayor and Kagan by President Obama, this remains a law and order, prosecution-oriented court. That's not only because Sotomayor and Kagan replaced 2 of the court's more liberal-leaning justices, Souter and Stevens, but because both Sotomayor and Kagan have joined the conservatives on the court in criminal cases regularly. The wins for defendants have come mostly in the areas of sentencing, where lower courts commit errors interpreting how federal sentencing statutes work, and in cases involving the intersection of criminal law with civil rights. Well, we've got 4 sets of cases to review. First, we take a look at habeas corpus cases. Second, we turn to the court's cases involving sentencing. Third, we'll take a look at a few cases with just straight federal criminal law issues. Fourth and finally, cases raising constitutional and civil rights related issues. Well, let's begin with the court's 5 habeas cases where nearly all of the results are against the defendants. The government wins these habeas cases so frequently, primarily because the federal habeas statutes, as amended by the Anti-Terrorism and Effective Death Penalty Act, really stack the deck against petitioners. According to Subdivision D of Section 2254 of Title 28, a petition for federal habeas that has been considered and rejected on its merits by a state court shall not be granted with respect to such a claim unless the adjudication of the claim resulted in a decision that was contrary to or involved an unreasonable application of clearly established federal law as determined by the Supreme Court of the United States, or resulted in a decision that was based on an unreasonable determination of the facts in light of the evidence presented in the state court proceeding. Now, under this language, it is not enough for the state court determination to be incorrect, and it's not even enough for it to be clearly unconstitutional under today's cases. Instead, the state court determination needs to have been actually an unreasonable determination of the facts or application of clearly established federal law, as determined by the Supreme Court, at the time the state court decision was made. These are very high standards to meet, and I think you can understand the tendency of lower courts, when they see a decision that looks wrong on the facts or the law, to try to fashion an argument that not only is that state court decision wrong, but it actually is unreasonable as well. But when these cases get to the Supreme Court, we see a fairly strict application of the deferential review required by the Anti-Terrorism and Effective Death Penalty Act. Well, the decision in Collin versus Pinholster is a great example. In Collin, the court faced a situation where the California Supreme Court had twice unanimously denied the petitioner's requested habeas relief on the merits, and the federal district court then granted the petition based on new evidence, which was introduced to the district court, but which was unavailable to the California Supreme Court. The court ruled by a 7-2 margin that this was improper, since under its interpretation of Section 2254D, the record under review is limited to the record in existence at the time of the state court decision, that is, the record before the state court. So the reasonableness of the state court decision must be assessed based on the facts before the state court and the law at the time of the state court decision. The remainder of the court's opinion, which drew only 5 votes, rejected the petitioner's ineffective assistance of counsel claim and reversed the Ninth Circuit's contrary decision, emphasizing the doubly deferential standard of review required by the Strickland decision for ineffective assistance claims and the Anti-Terrorism and Effective Death Penalty Act. Strickland already requires deferential review of counsel's performance, and the question under the Anti-Terrorism and Effective Death Penalty Act is whether the petitioner can show that the state court decision on the habeas claim necessarily involved an unreasonable application of federal law, or must have unreasonably concluded that he was not prejudiced by the ineffective assistance. The court found that the California Supreme Court's decision denying the habeas claim was reasonable on both counts of this standard. Now, the court reversed in 2 other Ninth Circuit ineffective assistance of counsel cases this term, Harrington v. Richter and Primo v. Moore. In both cases, the Ninth Circuit found that counsel's performance was deficient and prejudicial, And in both cases, a majority of the Supreme Court found that there were reasonable explanations for tactical choices made by counsel and reasonable decisions by the state courts denying relief. There were no dissents in any of these Supreme Court opinions. So the results here are not attributable to any sort of liberal-conservative split on the Supreme Court. Instead, it simply appears the Ninth Circuit is not on board with the direction the law has taken in conducting habeas review of ineffective assistance claims. Well, another good example of the deference required in habeas cases is Falconer versus Jackson, where the court slapped down another Ninth Circuit decision in a criminal habeas context. This time, the issue involved review of a state trial court's denial of a Batson motion. The prosecutor offered a race-neutral explanation for striking 2 out of 3 African Americans from the panel. The first because the juror might continue to harbor animosity towards all law enforcement because he alleged he had frequently been stopped by police because of his race, and the second because she had a master's degree in social work and had interned at a county jail, probably in the psych unit as a sociologist of some sort. The state trial judge accepted these reasons and denied the Batson motion. The California Court of Appeal upheld the denial. After the Supreme Court denied review, a petition for habeas was filed in federal district court, which that court also denied. Notwithstanding the substantial deference owing to the trial court's original denial, the Ninth Circuit reversed in a 3-paragraph unpublished memorandum opinion. The basis for the reversal was given in a single conclusory sentence as follows, quote, "The prosecutors proffered race-neutral bases for peremptorily striking the 2 African American jurors were not sufficient to counter the evidence of purposeful discrimination in light of the fact that 2 out of 3 prospective African American jurors were stricken, and the record reflected different treatment of comparably situated jurors," close quote. According to the Supreme Court, in its per curiam reversal, the Ninth Circuit's, quote, "decision is as inexplicable as it is unexplained. It is reversed," close quote. Well, lower federal courts are sometimes so anxious to correct what they think are state court mistakes that they forget that federal habeas is only about violations of federally protected rights. That's what happened to the Seventh Circuit in Wilson versus Corcoran. There was an issue whether the state trial court had complied with Indiana sentencing law by using only those aggravating factors authorized by Indiana law. The Supreme Court of Indiana accepted the trial court's explanation that it had in fact only used the authorized factors. The Seventh Circuit disagreed and was on track to require the Indiana trial court to reconsider its sentencing determination in order to, quote, "prevent non-compliance with Indiana law," close quote. Pretty fundamental error here because, as the Supreme Court noted, it is only non-compliance with federal law that renders a state's criminal judgment susceptible to collateral attack in the federal courts. The Supreme Court reversed in a short per curiam opinion. In another per curiam decision in Bobby versus Mitts, there's a pattern here. The Supreme Court reversed a decision of the Sixth Circuit, which granted a petition for habeas in a capital case based on the Sixth Circuit's conclusion that jury instructions during the penalty phase left jurors with the incorrect belief that they had to acquit the defendant of the death penalty before they could consider mercy and some form of life imprisonment. The Sixth Circuit was concerned that jurors might believe the failure to impose the death penalty could result in the defendant receiving little or no punishment at all, thereby encouraging the jurors to impose the death penalty. Problem was, the Supreme Court had upheld a virtually identical instruction in an Ohio case last term in Smith versus Spisak, although on slightly different grounds. The court upheld the instructions against this year's slightly different attack, essentially concluding that the jury at the penalty phase would not be at all confused by the instructions, which made it clear that if they didn't impose the death penalty, the defendant would receive a life sentence. So it was not as though the jury would believe that by not imposing the death penalty, the defendant might escape all punishment. Next, we have Wall versus Kohli, which is the only clear winner for the petitioner in the habeas context this year. In this case, the court interpreted the phrase collateral review in the tolling provision of the Anti-Terrorism and Effective Death Penalty Act. The Act has a short limitations period, providing that a habeas petition must be brought within 1 year. But then it tolls the period during pendency of a state proceeding for post-conviction relief or other collateral review. The idea is to keep the petitioner moving forward with his or her petitions while not charging the petitioner for the time it takes the state courts to make decisions. In Wall, the court held that collateral review meant judicial review of a judgment in a proceeding that is not part of direct review. Factually, the petitioner in this case had filed a motion to reduce his sentence in the trial court and then appealed from the denial of that motion. The parties agreed that this motion was not part of the direct review process, and it was therefore a type of collateral review, and the court held the tolling provision applied. Our final habeas case is the court's decision in Swarthout v. Cook, where the Ninth Circuit found itself on the receiving end of a judicial scolding. Under California's parole system, the Board of Prison Terms sets a release date unless it determines that consideration of the public safety requires a more lengthy period of incarceration. If the board denies parole, the prisoner can seek judicial review in a state habeas petition. The standard of review in that state habeas proceeding is whether there is some evidence that supports the conclusion that the inmate is unsuitable for parole because he or she currently is dangerous. The Ninth Circuit had adopted the practice of reviewing those state habeas decisions in subsequent federal habeas petitions, granting relief if the federal court determined that the state court had made unreasonable determinations under the some evidence standard. Well, unfortunately for the Ninth Circuit, misapplication of the some evidence standard was only a violation of state law, not federal law. And the Supreme Court has stated many times, including once earlier this term, that federal habeas corpus relief does not lie for errors of state law. Second, the Supreme Court had previously made it clear that when a state prisoner is denied parole, the only constitutional requirement is that the state provide the prisoner with minimal due process protections, limited to an opportunity to be heard and a statement of reasons why parole was denied. As the court explained in Swarthout, that should have been the beginning and end of the federal habeas court's inquiry into whether the petitioners received due process. Instead, however, the Court of Appeals reviewed the state court's decisions on the merits. That was error, since there was no basis at all for converting the state's some evidence standard into a substantive federal requirement. The court unanimously reversed. Well, that's it for our habeas cases. To continue on to the court's criminal sentencing cases, click on the criminal sentencing link in the Supreme Court Review table of contents.